Welcome to the Three Wisemen of Divorce, Money, Psych, and Law podcast. Sit down with the California divorce experts, financial divorce consultant Mark Hill, marriage and family therapist Pete Russos, and attorney Shawn Weber for a frank and casual conversation about divorce, separation, co-parenting, and the difficult decisions real people like you face during these tough times. We know that if you are looking at divorce or separation, it can be scary and overwhelming. With combined experience of over 60 years of divorce and conflict management, we are here for you and look forward to helping by sharing our unique ideas, thoughts, and perspectives on divorce, separation, and co-parenting.
So, guys, I got an idea for a topic for today's discussion. And actually, Shawn, something that you emailed was really, I thought, really powerful and interesting. You sent last week the piece about the different types of mediation. And I have never heard mediation broken down in that way. I thought it was really instructive. And so if you guys haven't talked about that yet on this podcast, I think that could be a really wonderful and useful thing to cover today.
Well, we could do that. We could talk about that. I mean, there are different styles of mediation. And I think the people out there that are listening to our podcast, you know, they're mostly the people that are actually maybe going to go hire a mediator. Mm-hmm. It's really important for them to kind of understand, well, what's the mediation style of your mediator? Because not every mediator is created equal.
And I think that I've always thought of that as individual differences, if you will, in terms of the practitioner, as opposed to, no, these are differences in models, if you will, or approaches under the mediation umbrella.
Yeah, so and there's very little regulation about what mediation is supposed to be. In California, there's pretty much zero regulation.
Yep.
And so... Really?
Yeah. I mean, anybody wants to be a mediator, just hang up a shingle. You're a mediator.
What about the thing that you both have talked about numerous times, that it's a confidential process? Are there things that...
There are protections in the evidence code. In particular, section 1119. I think all the mediation evidence code sections started section 1115. As we in the biz say, evidence code section 1115 et sec. And but 1119 encapsulates the confidentiality for mediation. And that is that anything that is said in the course of mediation, at least in the state of California, is absolutely confidential. And it's one of the strongest confidentialities in the entire evidence code. And we mediators are very jealous about protecting our confidentiality. Every time the legislature tries to do anything that might, impinge upon it, we band together and fire off emails and letters to our assemblymen and state senators, or assembly persons, I should say, and state senators to demand that they not mess with our confidentiality, because we know that confidentiality is very useful in helping people feel safe during their conversations. I don't have to worry, if I'm a party, that something I say in a mediation is going to be used against me later in a court of law. So you can be open and frank about what's really going down. And it's a wonderful way to encourage openness and communication during the mediation. But if people are afraid that they're going to lose that confidentiality, then what happens is people hem up and they kind of lawyer up, and they're worried that, I got to be careful what I say because it's going to be used against me later in a proceeding. And people could then abuse the mediation and use it as a way to get information. Strategy, and so what the confidentiality is really important. But yeah, that's really the only regulation, only rules regarding mediation in the state of California. It hinges on what is confidential and was not confidential. But as far as who gets to be a mediator, any yahoo can go hang their shingle and say, I'm a mediator. There's some states where there are rules about what you have to do to become a mediator. I'd say most of the time, if you're going to hire a mediator, you may want to make sure they're trained. I think minimum is a 40-hour mediation training or a 32-hour mediation training, depending on how good it is.
And that's the requirement for collaborative.
That is the requirement for to be a collaborative practitioner. most groups are requiring a 32-hour course. Mm-hmm. In fact, I teach a 32-hour course specifically for that purpose. But there's also what we've learned is that there's different styles of mediators and just how they approach what their voice will be in the mediation. And a lot of it, I think the paradigm really is it going to be a less intervention model, like less intervention on the part of the mediator, or more intervention on the part of the mediator?
And these are the 4 types that you identified in the piece that you sent out.
Yeah. And it's on my blog. If people are curious, you can go to WeberDisputeResolution.com and read the blog. And it's the title of the post is The Pros and Cons of the Different Styles of Mediation. I actually wrote this for professionals. I think it's a good thing for consumers to read as well, because it kind of gives you an idea of what to expect, But, to be really clear about what mediation is, you start off with mediation. It's a form of conflict resolution that involves a third party neutral. Okay. And that third party neutral doesn't get to decide. It's not like that third party neutral has a tie breaking vote.
The difference between an arbitrator and a mediator, which often gets.
Yeah. A lot of times I'll hear people say, well, we want to hire you for arbitration. And so then I have to kind of ask a little bit, what do you mean by that? But so arbitration is I get the tie-breaking vote. If you can't decide, then I decide it for you. Mediation, I'm just a neutral. I'm just a third-party negotiator, but I don't decide anything. You're in charge. And I say to my clients a lot of times, stay in charge, because if you leave mediation and go to court, then a stranger in black robes will decide your life. So stay in charge. But the 4 different types, I'll just kind of start where they are. So we got transformative. We have facilitative, informative, and evaluative. And you might talk to 40 different mediators that have even more different styles in between those, but I feel like those are the 4 main ones.
So how do they break down?
So, I'll start on the less intervention side. And the reason intervention is an important keyword is because an important ethical point for mediators is this right to self-determination that we want to afford the parties. Okay. It is considered a golden rule of mediation, and every set of ethical rules I've ever read on mediation, the right to self-determination on the part of the parties is the principal point, that they decide it's not my case, it's your case. But, to what extent can the mediator intervene to make sure that there's a process where settlement is possible? And there's different schools of thought. Now, when mediation first started, I think transformative mediation really got big. It was used by the U.S. Postal Service mediators. It was kind of in the early days, and it was completely non-interventionist. All the mediator would do would just kind of sit there and help the people talk. And there wasn't necessarily even a direction. I kind of think of it as, what's that kind of jazz where you don't even know what you're playing? You're just going to start playing stuff.
Improvisational
jazz. It's kind of like that. You kind of sit there and you kind of let it flow, or it flows. And what we're hoping is that we can get to a moment where there's a transformation of the relationship between the 2 parties, and then a settlement can occur. And this occurs because we facilitated. I want to be careful about using the word facilitation because it's a facilitative process, but we provided a forum where people can talk freely. But the mediator does very little to control the conversation, does not set the agenda for the meetings, does not provide any information, doesn't provide legal information. And, oftentimes, you'll sit down with a transformational mediator and they'll be like, okay, well, what are we going to talk about today? And that was the primary form of mediation for a while until we got well into the 80s. And then what started to develop was a version of that called facilitative mediation. And when you think of a facilitator, that's a person that's facilitating a conversation, right? And that person is more in charge of the process. I'm going to sit here and I'm going to control what the conversation is. I won't necessarily identify issues That's still up to the parties, but I'll facilitate the clients identifying the issues. And so I have a little bit more involvement.
Is it accurate for me to think of this as being dynamic driven? I had the image of guardrails, transformative mediation. There's a lot of room in the guardrails, and then if the dynamics between the parties are such that they need more structure, the guardrails, if you will, move in a little bit closer, and that the mediator is managing. And
also, it's really, I think there's an additional thing, Pete, as those guardrails continue to come in, which is the skills and the training of the mediator in a specific field. So when I'm doing mediation, my training's in the financial area where they're seeking that information from me. And so my role is to kind of interrupt them if they don't understand something about the finances, is the way I see it.
That brings me to the next step in the paradigm, and that is the informational mediator or informative mediation, as it's called. And I think that's, you and I do a lot of that, Mark. And that is where they come in, we're facilitating, but we're taking a step further. We're providing information. I'm telling people what the law is. You're talking to them about financial principles. You wouldn't do that necessarily in a purely facilitated mediation. You certainly wouldn't do it in a transformative mediation. And there's pros and cons to each model, right? So, going back to the transformative mediation, the pros are the parties have all the power. That's kind of cool for parties, right? To have control. They can experience personal growth. It's interesting when I teach this, I teach mediation. It seems that the mental health professionals seem to be attracted to transformative because of that personal growth component is there. They learn to communicate more effectively.
Well, it's interesting that I literally 30 seconds ago was thinking about my involvement in collaborative cases, and my services are way less needed in a transformative process. And I'm thinking in terms of the dynamics between the parties, where they're able to work collaboratively enough on their own that maybe there's offline need for mental health services. But it's in the process.
I think collaborative practice, this offshoot of the ADR movement that developed in the 80s, right? With our friend Stu Webb, who's been on this podcast before, you have this agreement that attorneys working together and then a professional team working together to include mental health professionals and financial professionals, that they sign an agreement that says they will never go to court. But in essence, what they are is an informational mediation team. They're providing information, and they're actually very rigid. I find collaborative processes to be very rigid in terms of control of the process, more so than what I see in any other mediation model. And I think that's just kind of a special way of, it's a pro and a con. It's a pro because the rigidity, your positive might be my negative. The rigidity can be a good thing because it helps people stay on track. The negative to the rigidity is that, people aren't rigid necessarily, and they sometimes don't react well to that kind of, So it's interesting for me coming into collaborative, having a mediation background. It was hard for me to kind of feel comfortable with a process with very strict protocols like what you have in a collaborative process. That kind of goes to my point is these mediators, when they're learning how to mediate, one of the things we teach them is, find your voice. Where do you feel comfortable? And maybe that's the type of mediator you'll become. So, I mentioned the pros of transformative is that flexibility, right? Well, the con is the process can take a long time because nobody's really in charge of what we're doing, not even the mediator. And they may not resolve the specific disputes. It may just, you can go down all kinds of rabbit holes. The other con is that it may not be very effective when you're talking about cases where you have power imbalances. If you have a situation where somebody is.
And I would add that it's not just power, but it's knowledge, because knowledge is power. So a lot of the times someone will come in knowing everything about the children, what they do every day and the other spouse has not been involved, and that really creates a power imbalance when it comes to talking about how child sharing should occur afterwards. Same thing with finances, obviously, too.
Sure. So then you move on to the facilitative, and what are the pros of the facilitative? Well, the parties still have a lot of control over the outcome, right? But the focus is very much on interests and needs. It becomes interest-based negotiation. And I think that the most common model for mediators who start in the facilitative process is the Getting to Yes books. Those are wonderful books. Oh, gosh, the authors are eluding me. Fisher and Urey. Getting to Yes. If you ever want to read a really good book on how to negotiate from an interest-based point of view, those are must read for any good negotiator, and they're a light read. I mean, the books are pretty thin, but the seminal book on negotiation, I think, is Getting to Yes, and facilitative mediators tend to use that kind of thinking around focusing on interests, not necessarily this is what the law says, right? But on what is it that the parties need or want. The negative is, and the other thing is facilitative mediation, I think, is less expensive than a lot of the other models because there's fewer resources brought to bear. It's just one person talking in a group, mediating. But the con is that it may not be effective for cases where you have the power situation, the power imbalance. Although I would argue that a good facilitator knows how to balance the room. So part of that is if you've got somebody that's a facilitative mediator and you're worried about a power imbalance, ask them, well, how good are you on high conflict cases? How good are you on balancing people's, participation? And then the other thing is, in facilitative mediation, you wouldn't give legal information or financial information. And so if you want a mediator that can provide that extra piece of information, then you might want to look towards a more informative mediation than a facilitative mediation. And then if we move on to the informative mediation, I think that's where Mark and I primarily live. That's where the mediator can provide legal information about legal rights and responsibilities, and that kind of helps the parties know what their choices are. We kind of describe, here's the backdrop of the court. This is what you could expect from a court situation.
I imagine that.
Go ahead.
I'm sorry. No, I imagine that. I'm curious if for the two of you, that seems like a more challenging dance, if you will, in terms of maintaining the neutrality.
Yes. Yeah, I think that's true. I find myself sometimes having to make a judgment call. Am I sharing what the law says on this particular issue, or what people's experiences are too? I will share that. Like, hey, some people do this and it doesn't work so well. Is that me putting my finger on the scale and then no longer being neutral? I mean, what's your experience, Mark, with financial?
Yeah, I mean, this happens. I mean, you're doing a case, you're reaching an agreement, and then suddenly I see, if they do that, this has a financial consequence that we haven't discussed. I feel I have a fiduciary responsibility to bring that up. But on the other hand, I don't want to blow it up. So we do make value judgments. If it's a rounding error financially in the case, and it is something that has caused conflict in the past, or there's been a lot of conflict in the case, you make a value judgment. It's not going to really change anybody's life. And yes, you're playing God to some degree. But again, our goal is to reach a settlement that is fair and informed. That's the way I think about it. And so the default is to share the information, but there are times when you do make a decision to perhaps hold back on it. And then, or even share it in a caucus situation rather than and say, what do you think? You're the one affected by this. Do you want to bring it up?
It's interesting. When I first started my work as an attorney, I immediately was mediating. In fact, I was mediating before I passed the bar exam. I took some mediation courses in law school, and I worked for somebody that was good enough to let me do some mediations on some divorce cases, and I got some experience. And I was allowed to do that because in California, anybody can be a mediator.
Right.
Okay. Mm-hmm.
But I was much more transformative and facilitative back then because I frankly didn't know the law very well. I was new. I was a baby attorney.
Mm-hmm.
As I've developed as a practitioner, and now I'm a 20-plus year veteran, I do know what happens in a courtroom,
Mm-hmm.
And so I feel like when people are paying my rate and, my rate's commensurate with my experience, they want and expect me to be able to opine on this is what the law is, or this is the kind of thing that where I had somebody ask me, well, we're thinking about nesting. What do you think of that?
Mm-hmm. Mm-hmm.
Nesting meaning the kids live in the house and the parents are the ones that move back and forth and just come do their parenting in the house while the other parent goes to an apartment somewhere else, and then they switch off. And I had to say, based on my experience, it can be challenging to nest unless the parties are very high functioning. Mm-hmm. And the dynamic between the parties is very strong. Can you be a power partnership? Otherwise, I wouldn't try it. Well, that's some information almost putting a finger on the scale, right?
Mm-hmm. Mm-hmm.
In reality, I've only seen maybe in my career one nesting arrangement that ever really worked.
Mark, I'm sure you've come across plenty of situations where you had to help people figure out an unrealistic financial situation.
Spouse is determined to keep the house no matter what.
Yeah,
right. And nothing can dissuade them from the fact that they must have the house. Well, I can share information that show that 5 years down the road, when the kids go off to college and the house, the one spouse is still remaining in it, there's no money. They don't have enough income to pay the mortgage. Do I share that? I think I have a fiduciary responsibility to share that, frankly, because yes, we're trying to get to settlement and we're trying to do it in a way that is equitable. However, things have consequences down the road, and I don't want to bump into that person in the grocery store 5 years down the road and they tell me they're living on the street or they had to go to an apartment in a poor neighborhood. Those are the kind of things where, again, is it putting finger on the scale? Yes, but it's doing it in a way I would say, from the very best motives, because if I don't share it, what is the consequence?
Mm-hmm.
Well, go ahead, Pete. Sorry.
No, I was just thinking that I think for me in my work, and this includes the work that I do in support of mediation, one of the most important questions that I ask clients, and sometimes I ask it before they're clients. I ask them when they're prospective clients. But certainly early on in my process is I ask people directly, how honest do you want me to be with you? And I think that the reality is that we are paid for our judgments. We are. Yeah. That's part of the expertise. That's part of the experience.
Peter, I really like that question because there is a time in every case where you have to be brutally honest about something.
Yeah.
Albeit whether it's about making a decision around something or how you approach something. I was working this morning on a proposal that one lawyer is working on one side for, and Shawn and I, in fact, are neutrals in this case. And I spoke to the lawyer and suggested some change of wording here and there to make it land better on the other side, because I know how sensitive the other side is on some issues,
Yeah.
But again, are we putting our finger on the scale? Perhaps a little bit, but again, from the right motives.
And a lot of this has to do with the skill of the mediator. A well-trained mediator will be a master of the reframe. Where they will take a problem and reframe it in a way that the other person can hear it from a neutral perspective.
Yeah.
And sometimes that also involves reframing. Well, this is what would happen if you went in front of a court, and saying that in a way that does not look like, well, yeah, I'm putting my finger on the scale, but I'm being very neutral here. And I'm just telling you, this is what the code says. And then being willing to say when it's ambiguous, and we have those cases don't we? Where people are like, they want a cut and dry, bright letter law, bright line rule on something, and that doesn't always happen in court.
Yep.
It's a court of equity, and Mark's always very happy to point out that provision in the spousal support provision, and where it lists all these factors A through H, and at the very end they throw in and anything the judge thinks matters.
Yeah, right. And I always tell people that because they just want to know the rules. Just tell me the damn number, I'll write the check. I've had that said to me more than once, and I'm sorry, there is no number.
So I tend to say, well, this is what the law says on this particular issue. Now, what do you want to do? You can do whatever you want, because, the judges are thrilled if people figure out things on their own. And with only a few exceptions, the judge will let people do whatever they want.
Yeah.
And as long as they both agree, that's the key. And so I come back with, as long as you both agree, you can do whatever you want. So you've heard, now this is what family code section blah, blah, blah says. Now, what do you want to do? And always put it back on them.
You both said a few minutes ago, Shawn, that what you and Mark do is really largely in this informational mediation model. What are the pros and cons from both of your perspectives?
Well, I mean, the pro to information is that you can actually give people expert knowledge so they can make informed decisions. That's key to informational. Legal complexities can be addressed without them having to go to a formal legal process, because they're hearing from somebody who's neutral, who doesn't have a stake in the game. This is what would happen, or what they think might happen, or people Vegas odds. The negative is that people, if they hear something like, this is what, let me run the support calculation. I run the support calculation, and then people will anchor on the support number that the software spits out. And that may not be the best number for their family.
And the other challenge we've had, Shawn, is when people go outside of the process, which is fine, and get information outside and come back and say, well, I spoke to a lawyer who said I would get A, B, and C. And it's it's easy for me because to some degree, I don't care if I offend a lawyer, but you're a part of the legal community here. And it's important for you to, have some, shall we say, be a little cautious around how you talk about other lawyers' opinions.
I've only thrown a few lawyers under the bus in my career. There've been a couple where I've been like, no, that's nonsense. That's happened. You might want to get a second opinion on that one. I've said, try to be very neutral about it. I love it when the attorney's there and I'm concerned about, is this going the right direction? Because then I can question the attorney. Well, did you think about this? Did you think about that? Well, what about this case? And force them to kind of defend themselves in front of their client. It's interesting when you see an attorney kind of stammer.
Backtrack.
When you ask them a question, I kind of do it like a judge would do in oral arguments. Well, what about this? Not because I want to make the attorney look bad, but because I want the attorney to be able to defend what they're saying so that the client can hear that. And then the other thing is, sometimes I will say to the client, okay, well, your attorney has made a very strong case and is doing a good job in taking care of you and making sure that your interests are met. Well, what do you want to do now? Maybe you have a very strong case on this, but what's a benefit to you if you go ahead and agree to what this other person is asking for? What's the benefit to you to just getting an agreement today, as opposed to, your attorney could probably go to court and do a bang up job on this, and I'll ask the attorney, well, how much is that going to cost for you to do that? They always underestimate it.
The other thing is that, I've done this with attorneys where I brought attorneys to the table, and I often will say to them, if you were on the other side, how would you argue this? And if you were on the other side, because I want the clients to understand the range of outcomes, range of possibilities, as opposed to it's either A or it's B, Because you get a slightly different take on it when you ask that question. You know?
Yeah. And just kind of understanding that there's risk. And this goes back to the principles of that book, Getting to Yes, I was telling you about. What Getting to Yes is teaching negotiators to do is to be very conscious of what is your best alternative to a negotiated agreement. And the short form of that is BATNA, BATNA, best alternative to negotiated agreement. Or what's your WATNA, your worst alternative to a negotiated agreement. And oftentimes people get that wrong because they've been living with the case. And so they may have a rosier BATNA and a rosier WATNA than they really ought to be having. And then when they actually hear what the other person's view of the case is, of what their BATNAs and WATNAs are, it starts to make people think, oh, wait, I've been hearing from this attorney that it's this, but really this guy went to law school, or this gal did. Why is it I got two smart attorneys here that are disagreeing?
Yeah. And that's powerful for the clients to see, because it goes back to what Shawn was saying about risk. You know, and you literally do not know what a judge will do. You really don't. You know?
How often do clients turn to you guys and say, well, what would you do?
Like if I was them, what would I do?
Yeah.
They ask me that, and I try not to allow them to pull me there, because the way I differentiate legal advice from legal information is legal advice is that should piece. What should I do or ought I do? Whereas information is, this is just what the law says. Or this is what financial principles are. This is what the says, right? Or this is from, if you were doing it from a mental health standpoint, this is what the research says on parenting plans for a 2-year-old. But when it gets to be like, what would I do if I were them? I tend to be careful about that, because I don't want that to then become an advice situation.
Well, and I imagine that you guys are often asked some form of the question of what would you do, or what do you think I should do?
I usually turn it into a question for them.
Yeah.
So if you agree to this, or let's say you went to court and you fought over this and then you lost, and the other side's position won, what would that mean for you? Oh, that would be awful. I don't know what I would do. That would be terrible. I'd be ruined, or whatever it is. And let them think about that and kind of macerate the possibility that they may be looking at the case from a perspective that was too much in their favor. And that's what happens. I mean, you get this information bias when you get in your silo. We see it in the media, right? Fox News has one information bias. MSNBC has another one. And if you don't listen to different perspectives, you're going to get more and more in your corner. And it may or may not be something that leads to something that's actually useful for them. It's not good to underestimate your risk, which I think people routinely do.
Yes, I agree. And they also come into this with the sort of, remember the Al Pacino movie, Justice for All? It's like, if I can just tell my story, I'll get everything. Once I get in front of a judge or in front of a neutral even, if I just tell this person how awful my spouse was, I'm sure that they're going to see things my way and give me everything. I mean, I'm exaggerating, but there is that people come into with that concept that we're here to pass judgment, as opposed to what Shawn's been talking about, providing information so that clients can make decisions jointly.
Now, the fourth version of mediation that we didn't talk about yet, but is nevertheless important, is the evaluative mediation. And this is the one that I would say is the most intervention on the part of the mediator. And this is the favorite for the judges, the private judges, the retired judges that go into mediation. And what you would do if you would hire a judge in this situation, what you're looking for is, what would you do if this case were in your courtroom? So they're evaluating your case. And so they will tell you, this is what would happen if it was in front of me. And it tends to be really useful for really complex cases where there may be complex legal questions that require a lot of analysis. And it may result in faster resolutions compared to some other styles because, you got the expert that kind of opines. The negative to it is that, well, you're giving up some of your self-determination by having a judge say, well, this is what I would do. And so they tend to anchor on what the judge is thinking. Mm-hmm. Even though that judge, we've said this before, you can show the same argument on spousal support, for example, and show it to 5 different judges, videotape it and show it to 5 different judges and get 5 different results.
Well, and I think, Shawn, that there are those cases where they may move from informative to evaluative to try to settle it, right?
And sometimes I've had to do that. So there is a tool that mediators have called the mediator's proposal. And this is when we've been working with a couple or two parties in a case, and they're just not able to reach a resolution. And then what the mediator will do is it's kind of, this is my take it or leave it mediator proposal. This is the last ditch effort. This is what I think you should do with your case. Here's my proposal. If this isn't good enough for you, then you're done. Go to attorneys and fight it out. Kind of a last ditch effort. With the evaluative mediation, you're kind of starting there, and that has its pros. I think it's really attorneys like that mode. Like whenever I'm doing a mandatory settlement conference at the courts, the attorneys want to know, what would I do? I'm looking at this from 40,000 feet. I haven't been living with this like the attorneys have. And they actually call me a judge when I'm settlement conference. When I'm facilitating a settlement conference, I'm called a pro tem judge. But what I'm doing is I am giving them a very strong evaluation. Now, I can't help myself. I still facilitate. Mm-hmm. There was another former judicial officer here in town who I really liked going to him because he would kind of hide the ball. He wouldn't opine yet. And then when we got to that point where it was really obvious we needed his opinion, he'd say, okay, do you want me to give my opinion now? Because once I give my opinion, it's out there.
Mm-hmm. Yep. Mm-hmm.
Do you want that? Do you really want it? Mm-hmm. Yes, we want it. Okay. Well, here's my opinion. And then I'm like, oh, dang, that just ruined my case. Or, yay, that's what I wanted, Mm-hmm. And then people tend to anchor. It does take some self-determination away because people tend to anchor on the judge's evaluation. Mm-hmm. Mm-hmm. But it can be useful. I mean, we got this case, Mark, where we're talking about a prenup, and we've been talking frequently about we're not sure how the prenup would be handled. Yep. And it's a key issue. And the thought was, well, what if we go to a private judge to have that judge simply opine on the issue of the prenup? Mm-hmm. Yeah. And give an opinion on what would happen with that prenuptial agreement. And then once they know, then we can come back to mediation and have them use their interests in light of how the prenup would be handled so that we can now move forward. But they actually ended up figuring it out without doing that.
Shawn, would you clarify something for me, please, about confidentiality? And this is the question that I have. My understanding is that if a case falls out of mediation and people leave it to go into litigation, they own their case file. Is that correct? And what does that mean in the context of mediation or confidentiality?
So mediation, it's a little bit different. So in a legal situation, they own their case file. They're entitled to everything in your file. Mm-hmm. And when the case is over, it's actually their property. And if they request their file, you have to give it back to them. Mm-hmm. And most of us we go through these backflips because does that mean I'm going to have to store things ad infinitum in storage till end of time? Yeah. And so most of us have like a time limit. Well, I'll hold your stuff for 5 years. And then after 5 years, spread your file if we haven't heard from you. Mm-hmm. Otherwise, I have to affirmatively ask permission to destroy a file.
Oh, interesting. Okay.
And if they request the file, we have to give it to them. That comes up sometimes in collaborative cases because you have this attorney and they've agreed to this confidentiality within the collaborative process.
Yeah.
And then the case goes to court, and new attorney that's going to litigate this case, they're like, okay, give me the file. I want the file. And then the collaborative attorney's like, well, I don't want to give you all the file because we agreed that some of that would be confidential. And I haven't ever seen it tested, but I think if it were tested, the attorney would have to give it to the attorney. I think it would have to be turned over.
So what does that mean in terms of confidentiality?
Well, it doesn't mean that it then gets put into evidence at court.
Okay.
What it means is the attorney is entitled to the information, but then anything that is considered confidential can't be brought up. And we're careful in collaborative cases to sign a stipulation that says that we're using 1119 of the evidence code, which is the confidentiality section for mediation, applying it to our collaborative work. And we're saying you can't use anything we said during our conversations and discussions in court. But there's still work product that the client's entitled to, you know. And I think that may be true in mediation as well. Except I don't turn my notes over. I have it in my agreement that I don't turn my notes over. My notes are mine. They're kept confidential. And what is something that survives the process, and this is according to case law, is their financial disclosures that they prepare that are required by the courts. In California, there's an income and expense declaration, a schedule of assets and debts, and then the backup information, the evidence to support what's in those declarations. Those survive the process and can be used by the new attorney. But everything else is strictly confidential.
Okay.
And my rules, I think, are slightly different. I mean, I say very clearly in my retainer agreement that if the case falls out, all my work product is confidential. They can agree to use it, but one side can't use it. So if they've sent me anything, that is shared. So any information that the clients send me around the finances, that's shared. Any work product that I've produced, though, is not for sharing unless they both choose to do it. So sometimes in a case, we'll get deep into it. And we've agreed some things, and we've got some work product that we provided to them that's part of that agreement. But now they're going on, they're stuck on other things. They could choose to do that, but if either side has a veto, they can say, no, that cannot be used because I don't agree to it being used.
Well, an interesting way that 1119 of the evidence code is used is that not only, nothing that is discussed in mediation can ever be used in court unless everybody agrees to it, all parties, and the courts are interpreting all parties to mean, and that means the mediator too. And so, I've had people like, we want you to testify in court about what happened in this mediation session. I'm like, pound sand. And then they're like, well, we're going to send you a subpoena. No, I'm not going to do it. Well, both sides agree that they want you to come into court and testify about what happened here. I'm not doing it. And so then, they try to push it, and I can show them the case law on that. No, look, I am a person that counts. I don't approve of this being disclosed in court because I really want to protect what was discussed. And so it's a very strong confidentiality. Like, even if both parties agree that the information can be used in court, the mediator can object.
And just to reiterate, Shawn, that's how it is in California. It may be different in other states.
It may be different in other states, but most states have a very similar approach. I'd say the majority of the jurisdictions will do that, but check your local jurisdiction if you're not in the state of California and make sure on that. Yeah.
Well, just to the audience, I really want to, if this has been interesting, I want to encourage you to go to Shawn's website and look up the article. I found it very helpful and fascinating.
Well, I'm glad that somebody's reading my stuff and finds it worthwhile.
Yeah, as I say, I have never heard, and it made so much sense to me. I've never heard mediation broken down in that way. So well done, really well done.
Well, good. Well, we've been talking a long time.
Yeah,
we have.
I think maybe we can stop now.
Yeah.
I think our audience might appreciate that.
So Pete, if people wanted to talk to you about mediation or about services you provide, what should they do?
Best way to reach me is my website, which is peterroussos.com. That's PeterRoussos.com. And you can contact me through the Contact Me page.
And Mark, what would they do if they needed to talk to you about some financial stuff?
Same approach. Go to my company website, which is pacdivorce.com, PACDIVORCE.com. There's a contact page there, and there's also our phone numbers.
And if people want to get a hold of me to find out how to resolve their dispute, we will match them with a mediator to resolve their dispute. It's WeberDisputeResolution.com. That's Weber with one B, dispute like we had a fight, and resolution like we solved it.com. And you can go there and find all kinds of things, including, according to Pete, very good and interesting blog posts. And this podcast is on there as well. So we look forward to people checking it out.
Thanks for listening to another episode of the Three Wisemen of Divorce: Money, Psych, and Law. If you like what you heard, be sure to subscribe, leave us a review, and share with others who may be in a similar place. Until next time, stay safe, healthy, and focused on a positive, bright future. This podcast is for informational purposes only. Every family law case is unique, so no legal, financial, or mental health advice is intended during this podcast. If you need help with your specific situation, feel free to schedule a time to speak with one of us for a personal consultation. Thanks for listening to another episode of the Three Wisemen of Divorce: Money, Psych, and Law. If you like what you heard, be sure to subscribe, leave us a review, and share with others who may be in a similar place. Until next time, stay safe, healthy, and focused on a positive, bright future. This podcast is for informational purposes only. Every family law case is unique, so no legal, financial, or mental health advice is intended during this podcast. If you need help with your specific situation, feel free to schedule a time to speak with one of us for a personal consultation.